Thank you for joining us here today. We're going to have a conversation about artificial intelligence and one about prompting in particular. It's a topic of extraordinary importance. We'll dive into it here in a minute. We're not ready to begin yet. We'll let some people enter the room. We had a tremendous response to this, partly the topic, I'm sure, partly the CLE that we have promised as well. Let's just give folks a moment to get here, at least everybody that was waiting in the ready room before we started. Okay, it looks like our numbers are still growing pretty quickly, but we could probably get started here. So thank you, everyone. Thank you, everyone, for joining us here today. My name is Gene Quinn. We have a topic of great importance to talk about here, AI prompting for patent prosecution and preparation. We're going to talk about the latest techniques that every patent practitioner should know about. Thank you for joining us here today. This will be a CLE webinar. I'm sure you've got that information handy, which is why everybody is probably here. We have the CLE materials were linked to the page where you registered. So what I'd like to do right now is just kick it over to Renee to introduce the speakers so that we can get going.
Sounds good. So today on our panel, we have Yuri Eliza. He is the CEO and co-founder of Junior and a U.S. patent attorney known for his deep expertise in protecting innovation. He previously led the IP practice group at Founders Legal and has been recognized on the best lawyers and super patent lawyers lists for his work securing high-value litigation-tested patents. Yuri has advised everyone from startups to major companies like Microsoft, Cisco, AT&T, and Coca-Cola, and has even trained USPTO examiners. With a background in electrical and computer engineering and experience founding technology companies, he brings a rare blend of legal, technical, and entrepreneurial insight to the patent field. Next, we have Gideon Miles. He's the Associate General Counsel of Patents and Trademarks at OpenAI, where he specializes in all aspects of IP, including the development of and day-to-day execution of patents, trademarks, and open source strategies, policies, and procedures. Prior to that, he was a software engineer at Apple and IBM Research, as well as an associate in private practice. He holds a PhD in computer science and a JD from Santa Clara Law School. Next, we have Eric Mashoff. He's a registered patent attorney and partner at Mashoff Brennan. He is also a co-founder of the firm, helping to grow it from a small team into a leading IP firm. Drawing on his background as a computer hardware and software engineer to solve complex IP challenges, he advises his clients ranging from Fortune 100 companies to startups on patent strategy, portfolio development, licensing, and IP transactions. He's also taught patent law at the University of Utah for more than 20 years. Next, we have Matthew Grady. He's a shareholder at Wolf Greenfield, where he leverages his strong computer science background to help U.S. and international clients build smart business-aligned IP strategies and protect their innovation in areas including database design, medical devices, and imaging, communication systems, and more. Matthew is known for delivering tailored guidance to clients of all sizes, helping them balance real-world business needs with the development of strong, forward-looking IP portfolios. And last but not least, we have Gene Quinn. He's a patent attorney and a leading voice in innovation policy. He founded IPWatchdog in 1999, now one of the most influential platforms in the IP space. Recognized globally for his expertise in software patentability and U.S. patent procedure, Gene has been named among the top 50 most influential people in IP and repeatedly honored as a top IP strategist. We also have Miriam. She's the Chief Revenue Officer at Junior, who's available to answer any questions during the webinar directly for Junior using the chat box. So back to you, Gene.
Great. Thanks a lot, Renee. And again, thank you for joining us. If you have any questions for the panel, please be sure to put them into the Q&A box. I'll be monitoring the Q&A box. We'll try and get to as many questions as we can. If you have a question for Renee's team, technical support, or one specifically for Junior, you can put that in the chat. Feel free to chat amongst yourselves as well. The chat will get very busy with this many people online, so I'm probably not going to be able to keep up with the chat and the conversation. So definitely use the Q&A box to get a question to the panel. So, gentlemen, let's start with your preliminary thoughts on this important topic about prompting, and we can go around the horn. Gideon, let's start with you. Where do you think people should be thinking? What do you think they should be thinking as we start to roll up our sleeves and have this conversation today?
Yeah, thank you. Very happy to be here and excited to kick this off. I'll preface this with I'm not an expert by any means when it comes to prompting, using these tools. I do work for an AI company. I do use AI every single day in my job. But I think it's really about continuously trying new things. And I see these tools not as being something to fear, not to fear that it's going to take away our job, but they're really here to help us augment our job and enable us to improve our skills, our efficiency, kind of raise the overall bar as to the work product that we're producing.
Great, excellent. Thanks a lot, Gideon. Eric, let's go to you next. What are your initial thoughts on the topic?
Yeah, so thanks for having me because I'm exciting topic. So as a mid-sized law firm, we're going through a lot of the struggles. How do we adopt AI? How do we integrate it into our practice? And so I'm super excited to talk about it. I think my viewpoint, at least at this point, is well, a couple of things. So AI is, I think deceptively easy to use, but it's really hard to master. And what I have seen in our law firm, and I think with others, is that most people treat it as like a search engine. So we're used to the Google search engine, and we tend to take whatever it is that it gives back, and we're usually frustrated with it. And I think people are reluctant to adopt it for that reason. And I think, and I guess what I advocate for is if you have a clear purpose and you understand how to coach the AI, how to prompt it, the results can be remarkable. I think it's going to change how we do our jobs. But if you treat it as a magic button, draft me a patent, and then walk away with that product, what you're going to find is the output is predictably hollow, or I guess what the kids refer to as work slop. So, I think my position is let's move beyond the magic button approach and stop asking AI to write us a patent, but adopt a structured, integrated approach in terms of how we approach the drafting process and using AI as a tool. So I guess that's sort of where I'm coming down on this, and I think what I'm going to talk a little bit more about today.
Yeah, excellent. I like that. I'm going to probably steal that. Get away from the magic button approach to AI. I mean, and that's really what we're here to talk about is how do you actually roll up your sleeves and use this to get the results that you need. So thanks a lot, Eric. Matthew, your initial thoughts.
Thank you, Gene. It's a pleasure to be here, and it's a pleasure to be with this panel. Eric, your ideas and mine are very well aligned, I think.
Well, I'm glad I went first then.
Yeah, absolutely. But being an attorney and being on our policy group, for developing use of AI, one of the first things I always have to mention is we have a duty here for ethical and responsible adoption of technology. So our use of AI has to meet that duty. And so that's one of the reasons that we have to be a little cautious with it. But the reality is that the potential for AI is extraordinary. The potential to streamline our process, streamline our workflows, even just give us roadmaps for how to handle work and how to interact with other people with respect to our works. Our clients are often using AI to evaluate the work product we send them. And so you want to be prepared to discuss it with them and discuss the elements that it like a ChatGPT or another model is going to feed back to them. Here's where they did well. Here's where they could have improved it. So those options, those potential there is just extraordinary. I think it was the CEO of NVIDIA who said, AI isn't going to replace your job, but somebody using AI might. And so that's why we all have to stay on top of this. But in my mind, the flip side, because it's so extraordinarily powerful, the potential risks are as well. And I have another favorite quote I'll throw at you. Uncle Ben said to a young Peter Parker, with great power comes great responsibility. And, for any of the Spider-Man fans out there, it's something that I take to heart every time I use these tools. Let's be really careful about we use it, but if we structure it right and we interact with it, in increments rather than big, give me an application. No, give me, a description of this element. These types of prompts will return better results that you can review quickly and efficiently and really generate a better product. Sorry for taking a little bit longer.
No, no, no. That's a good intro. I appreciate it. Thank you very much, Matthew. And last but not least, Yuri, your initial thoughts here.
Thank you, Gene. I'll keep them brief. I want to thank you guys. I have worked with people who prompt for patent drafting for several years, and the panelists here today, Gene, they are the ones who are truly thought leaders, and I've been impressed myself to see their methodologies, their workflows, their process. And it's very important for today to have those people on the panel, because the reason I believe this topic is critical is because of our duty of competence. Our tools are changing. Our tools are changing. We are going to re-envision word processing for drafting patents. We are not going to be writing individual words that go into that application, perhaps. And so we have to learn these new tools. That is our ethical duty. And I know we have a brief ethics portion here, but that's our ethical duty to our clients, to the profession. So that's my brief thought is we must be competent in prompting.
Yeah, because if you're not, you're going to get garbage. And if you are good at it, you don't get garbage. It's really that simple. And the better you are, the better the output is. And I think that's fundamentally why when you talk to some attorneys, they'll tell you, oh, AI, it sucks. It's terrible. Don't use it. I don't want to use it. It takes more time, etc. And then you talk to other people and they're like, no, I don't know what you're talking about. It's extremely useful. You get good results. Yeah, I have to check it maybe, but that's no different than checking an associate, or a patent agent that's working under you. And if you're not in the second camp, it's because your prompting skills aren't where they need to be. So, Yuri, let me share the results here very quickly to the first poll question so the speakers know the level of use people have. A lot of people are already using it, but we have a good number of people that are considering using it for the first time as well. So, Yuri, why don't I kick it over to you? I know you've got some information, some competency, confidentiality, ethics, if you will.
The fun stuff.
The fun stuff to make sure everybody gets credit because we're talking about real legal stuff here, as if right. Using the tool isn't legal enough, but right. Got to keep the CLE gods happy.
Absolutely. And let's keep it high level as well and fly through this. Here's the legal framework for adopting AI as I see it. And of course, I'm standing on the shoulders of thought leaders like Eugene, Matthew. You've put out a good article on this, and there's a lot of content released by the ABA specifically about adopting AI. So let's run through these and tailor them to our profession. Starting with the duty of competence. I see this in a few ways. You have to be competent in your practice. You have to use your tools competently. You owe that to your client. And when there's a tool available, like a generative AI prompting model that you use, you have to be good at it, right? That's part of the competence. But for patent attorneys, I think there's a second prong to this, and that is I have to be competent in the subject matter of my writing. What is the technical area I'm writing in, and do I have competence in that field? And that's where AI gets interesting. It helps you stretch that competence a little bit. And it's persuasively good at writing because it's written so well. And when you read something that's written so well, you tend to think, this must be right. This person knows how to express it so well, it must be right. So we got to watch out for that, just to make sure you still have some background knowledge in the area you're writing in. So technical competence, and anyone on the panel is always welcome to chime in here. The next duty, client communication. And, believe it or not, this is an interesting one because I've been asked by somebody, well, what if I have a completely local LLM and it's never goes on the internet? I built it myself at home, and keep it running in my garage. Do I have to disclose that to my client? Do I have to disclose to them if I use, what is it, Lotus Works or Microsoft Word? Well, the general answer is yes. Disclose it. Explain to the client and get consent from the client that you're using large language models. Now, I'm wondering if anyone here on the panel would differ. If you got a private, local, spun up instance and you're using it, as long as you're reviewing it, do you have to disclose it? That's just an open question to the panel. My stance is get your client's consent.
As somebody who is a client, I would say yes. I would definitely want to know if somebody was using particular technology. I mean, just the same way as like I'm pretty aware of, that they're using Microsoft Word to draft the application.
Yeah,
That's right.
I would agree with that. And in fact, I think there are certainly clients that require their outside attorneys to disclose to them whether or not they are using AI, and also have, it behooves us to make sure that if we are using AI, not only do we disclose it, but we're in compliance with those client policies. And there are some district court judges that require you to disclose the use of AI in connection with a brief, for example. So I think you have to constantly be ahead of that curve in terms of disclosure of your use of this particular tool.
Yeah, and I agree. Ultimately, if in fact, I advise clients to include in their own policies and agreements with law firms terms that are explicit, that say you have to tell us when you use AI for our work product. And we want to either approve it or at least know about it before you do. And those are I often counsel clients to put that in their engagements with law firms, just to make sure that everything is above board and no surprises. Nobody likes surprises in these types of scenarios.
Thank you all. No surprises indeed. Confidentiality. Let's combine that with conflict of interest because we want to fly through these and there's not much more left. The reason I'm combining confidentiality and conflict of interest is confidentiality, to be honest, that's generally the easy part. And it's really up to the client if they're going to allow you to use which model or public models. You definitely have to disclose that. But the conflict of interest part is very interesting in our profession because we cannot represent two of the competitors, even not competitors, they got the same subject matter, because I can't promise that I won't bleed, for lack of a better word, one invention data with another in my mind, and of course be a silent inventor proposing alternative embodiments, accidentally commingling some related art from another client I represent. That's always a scary thought. And so same applies to AI. Even if you say we've got a siloed instance, how well are you isolating and segmenting the data that goes into each application? And are you auditing that data as it goes through? So keep that in mind. In your, can your different, in your foundational model, let's say ChatGPT get in, you might have several projects on the enterprise edition, everything's confidential, private, great. But can those projects know about each other and inform the output that you get? So be careful. I'm sure there's a toggler setting, and maybe Gideon, you have a remark there, but I'd like to watch out for this one. All right. So this one is the last one I'll cover today, because the other one is reasonable fees, and I don't want to go down that rabbit hole. But non-lawyer assistance and the unauthorized practice of law. Companies like AI service providers or solutions providers might be careful here because bar organizations might begin to be interested in certifying or otherwise providing a methodology by which consumers of legal services are protected from software solutions that say they are a digital lawyer. We'd love to be called, Junior, the AI patent agent, but are we allowed to say that? Will we mislead non-sophisticated consumers of legal services? So this is one we have to watch out for in the industry as we provide solutions. So that's all for this segment that I've prepared, Gene. Does anyone else want to add anything else? I'd like to just make sure this part is quick and we can get into the prompting segment of our discussions.
Yeah, that would be great if we can move into that. And Yuri, since the panel doesn't have anything to say at the moment, we can move right straight away into prompting. Now, I think you have prepared a little bit of a video to show people. Can you lead us into that video? Tell us what we're about to watch.
Absolutely. Yes. So this is my 20th year in the patent profession, my 20th year writing patents. And I've drafted hundreds, like many of the folks in the audience and on the panel, patents for big corporations. And I was grinding my teeth on Microsoft, Cisco, Cox applications, and I learned a lot from that. And here are some core principles that I've learned that inform my prompting. First, my technical competence in drafting patent applications relates directly to the methodology I use to deconstruct the invention I'm writing about. That's one. Two, my technical writing skills in patent drafting relate directly to the methodology I use to reconstruct the invention, how I put it all together, right? Together, these combine to form what I believe is my technical aptitude for ultimately writing patents in a technical area, and is perhaps the most resource-heavy requirement I have as a practitioner. The heaviest lift is a technology that you got to study a lot. Now take that technical aptitude and let's add two factors when you serve large volume clientele that file a lot of patents. I've got to adapt my technical competence in the reconstruction of the inventions to the principles of patent law. The practice standards established and regulated over time, and this is where senior practitioners like Gene, like Eric, like Matthew have a huge leg up, is they've seen a lot of reps with the USPTO and they've adapted their...
Sorry for interrupting. I see a message here and I agree. We don't see your screen. There's a blank page. So apologies for interrupting you. I just wanted to make sure if you have a slide you want to show us, we see it.
I think we're going to dive into a video, but so adding, and then on top of what you learned is writing patents, you've got the drafting guidelines that were established by your client, by your practice group, and ultimately that's the client owner. So with these core principles, which I'm happy to dive in during a prompting segment, I began to develop a product for my team, and my co-founder Mark, with whom I've worked for many years, he's developed a product that many of you may remember was ReTech's Patent Advisor. And together, we dove into Microsoft Word to change what it means to be the word processor for patent drafting. And so we have a brief video to introduce how you would prompt inside Microsoft Word as a demonstration. Thank you, Renee. And I think we need sound here, Renee. We might want to restart with sound.
Can you hear it?
No, we're having some technical difficulties here that I can't really explain. I am unfortunately at the moment locked out of all the controls on Zoom. So Zoom seems to be having some kind of an issue here. So I apologize for this snafu. This is not usually the way that it works here. Renee, did you pause the video?
I did. I'm trying to, it won't allow me to check the share button again. So give me 1 second. I'm gonna try it one more time
Yeah.
to share the audio, the introduction. Cancel.
For the audience here, I'm getting emails that
I understand. Let it give us a moment.
Oh, no, I was gonna say something good. There's so many people at this webinar that no one else can get in. So if you're here, you might want to stay because other people can't get in.
All right.
Yeah, I that's another thing that I don't understand what's going on. Oh,
And we should be able to hear
who
it.
just did something? This
I did. Let me play it. There we go.
okay, because the
Should be able-
controls just popped up and then they went away again.
Here, let's see if it'll play.
By now, most of us have some familiarity with prompting foundational Gen AI models. But the workflow is broken and scattered across multiple platforms, and the outputs remain inconsistent and unpredictable. Many of us in the patent bar are counting on the next generation of practitioners to lead the way in adopting AI in an effective manner. Finally, after years in development, the new Junior has arrived. Junior is your AI patent agent with the technical know-how of the premier AI models, merged with the guidelines of patent drafting established by the applicants and practitioners you train it to model. By now, most of you are familiar with the well-known chat interface, but Junior's flagship capability is in its prompt sequencer and fine-tuned patent prep and pros modeling. Junior's prompt sequencing module is designed for the technical patent draftsman with a substantial volume of work in which they have established structured guidelines for drafting based on invention type, practice group, or applicant. First, let's see how we can adapt the well-known chat-based workflow to co-work with Junior. I can select from a plurality of different models and easily toggle between them throughout the session. This gives me an instant A-B comparison of the output produced by the different models. Junior will study the context surrounding the location of my cursor and load the right underlying models to ensure a compliant output. Let's draft the background of the invention. We'll start with a specific prompt. We could also sequence multiple prompts such that Junior will execute the prompt sequence in order to fill in the complete section. We could also highlight any output and ask Junior to rewrite it. We can have a brief conversation with Junior, provide it instructions, and iterate back and forth before finally inserting back into the document. Junior allows me to fine-tune every prompt sequence parameter, including the context level and its creativity. I could also choose specialized fine-tuned models and order them in any sequence I'd like. Junior allows me to create and save various prompt sequences for each section of the patent application. I will now save the sequence of prompts and choose to make it available to my other colleagues who work on the same invention type or the same applicant so that they can quickly load and reuse these sequences for subsequent patent applications. When I have multiple colleagues working for the same patent families or similar invention types, I can use Junior's knowledge management modules to ensure their output remains consistent with the appropriate drafting guidelines for each application. For instance, I can navigate to the Rules tab in which I can input specific drafting guidelines that layer on top of Junior's patent training. Junior customizes based on various input parameters, including training materials such as priority documents, sample specification sets, and template shells. Junior uses this material to extract boilerplate language, study your syntax and structure of the draft, and reuse terms and definitions where applicable. For instance, when writing the detailed description, I can load a system sequence that is tuned specifically to the way I write about system diagrams. I can adjust the fine-tuned writing style, as well as the context and creativity parameters for each of these prompts in the sequence, and ensure that the right enabling models are covered for this invention type. Let's say you're an in-house attorney reviewing a patent application provided by your outside counsel. Or say you're a client owner at a firm reviewing a colleague's work before submitting it to your client. Junior allows you to build and load from a library of agents unique to you or shared across your company. Here, I'll run Junior's agent to check for the enablement and written description requirements. Although I should note, I could combine multiple agents to create a new agent designed to run through a combination of these sequences in any required arrangement. Let's run through the enablement review agent and make some corrections and modifications. As Junior makes its propositions, I can review them and choose to accept or reject them, injecting it into the document accordingly. And when I'm done, I click Save. This will help Junior learn from the editing session to improve the workflow of the revision process for the next time I run this agent. Junior's agents can be used for office action response modules, or a PCT nationalization module. For instance, here, I'm asking Junior to convert this application to EPO standards. Thank you,
Okay.
Renee. Thank you, Gene.
Great. So I still don't have any control here, so we're going to need I'm going to need some help as we go through this. Let's bring in the rest of the panel though to the conversation. Matthew, since you went last time, let's have you go first this time. Thoughts on what you just saw and maybe prompting in general as we sort of pivot and get into that portion of the conversation today.
So what you're seeing there, and what I think is really exciting, is these agents that are implemented to step you through each of these elements of the patent application, rather than trying to prompt a model to say, draft me a patent application. I think everybody knows how hit or miss that can be, and actually it leaves you unable to review the material that's being generated. So building it in sequences is really the prompts that we were going to recommend, that I think, and I suspect Eric has a few suggestions on this as well, about how to build pieces of the application, how to look at it, what elements you want to focus in on. Myself, I like to build my prompts around claims, claim elements, make sure that they're all there, how are they described, and it builds into later validation of those. Again, I think purpose-built tools are kind of really next level here. Although I think that you can achieve similar functionality in the general models if you really constrain your interactions and you kind of build conversation settings or personas. So there's ability there as well. I have to say that when Yuri presented his tool, I was really impressed with the functionality that I saw there. And I think it's really going to help speed the workflow, allow you to build better review and revision processes when you're doing these applications. And so I'm really excited about what that means for us as we're working on these applications.
Okay, great. Thanks. Gideon, your thoughts?
Yeah, I mean, I've been impressed with that particular tool. I think that it nicely highlights a variety of the things that AI is now capable of doing, but has it not narrowly focused on specifically the patent practice. From the in-house perspective, I would say that my interest is more in what capabilities do I have in order to review documents that outside counsel have prepared. Like some of the editing functionality is useful. But I want the ability to be able to go through the document, make changes, understand what's in there, really get the content out, and maybe some of my suggestions in.
Thank you, Gideon.
Okay, great. And Eric, your thoughts?
Yeah, so I love the tools, the specialized tools, because they sort of help you establish the guardrails that you need. So, a couple of things that I've learned in connection with using more of the general LLMs is a couple of things. And we talked about the magic button fallacy and how that's not a good approach. The reality of these large language models is they are probabilistic engines that they're trained on the average of the internet. So when you ask them to do something, they're going to give you the average. And in a patent context, the average is obviousness, right? So we don't want that.
Right.
The other thing you get, and this is just based on me messing around with things, right? And sort of arriving at an area where the tool is useful for me. The other thing that I see is without the guardrails, without the good prompting, you get this narrative drift, right? So if you give one of these, ChatGPT 5 or Gemini or whatever it is, the tool that you're using, an enterprise model of it, if you give it a disclosure and there's gaps in it, the LLM tries to fill those gaps, and usually when it fills those gaps, it starts making things up. it conflates the prior art with your invention. It adds things that features to fill space. Again, what Junior does and what, I think some of the techniques we're going to talk about today are you have to implement guardrails. You have to take discrete steps. Don't do it all at once, because all of these LLM idiosyncrasies start creeping into your application. So, at least in terms of how I think about things, when I think about what makes a great patent, any great piece of written material, it has a consistent narrative thread. And so, in terms of what we're doing at our law firm, uh, we try to prompt to this narrative thread. And a great patent starts with a problem statement. Uh, from the problem statement, you go to uh, the inventive concept, the solution to the problem. Once you've iterated to a really good inventive concept, you draft your independent claims, perhaps one or two independent claims. And then you can iterate through portions of your detailed description, but you maintain that narrative, right? So that's the narrative that gives rise to a fantastic patent. And if you start with step one and you use the results of step one to go to step two, you implement the guardrails that I think Junior does or some of these other tools, uh, and you prevent hallucination, so you can catch hallucination very early in the process and get rid of it. You can make sure that the AI engine, the LLM, is staying focused on what you've identified as the inventive concept before you lead into the claims. It's not necessarily better prompting, it's decomposition of the process into discrete sort of pieces that lead to this golden thread that leads to a really good patent. And that sort of is what I've learned in terms of using the AI engines to draft patents. And once you once you get to this point, it is unbelievable how powerfully you can uh, create in an efficient amount of time and really end up with a great work product. You end up with a good patent with that narrative. If you stay away from the so-called magic button approach.
Okay. Excellent. So now what we want to do is move into some of the specific talk. And Gideon, I know you are going to talk about particularly the pre-patent drafting aspects of prompting. So let me turn it over to you. And while you start there, I'm going to try and force quit and be right back and see if that gives me any more control.
Excellent. Yeah, I'm, want to bring the kind of in-house perspective and share how you can leverage some of these tools in order to tackle the in-house role. So one of the areas where I spend a lot of time is on the invention identification and evaluation phase. And I find that these tools are extremely helpful in this process. Before AI tools, I would spend a lot of time reviewing product and engineering documents, identifying the technical problem and the solution, writing up an IDF, drafting a sample claim to try and illustrate the direction I thought we should take this particular claim, what I thought was the novel piece and what I wanted outside counsel to focus on. And then preparing kind of my filing recommendation so that I could discuss it with the team. With these tools, I can do all of this in just a few minutes. And I generally walk away having a deeper understanding of the invention than when I just passively read the documents. So I can make this a more active process. I can augment my understanding as I'm going along by asking specific questions. And to try and give you an idea of the workflow that I use for the invention preparation, the prompting can actually be pretty straightforward because these general purpose tools are very good at summarizing things. So I generally will start with something like, I received these documents that I then upload from one of our engineers who works on X product. Can you review the documents and provide a brief explanation of the technical problem they are working on and a summary of the solution? The summary shouldn't be more than a couple paragraphs max. Please highlight the key aspects of the solution. And then from there, depending on like what level of familiarity I have with the technology space, I'm likely to ask some additional questions like, how does this solution differ from Y or Z that I'm already familiar with? Just provide some key bullet points. Or can you find similar products or product features? If you find something, how does our solution differ? And from here, what I can do is take these responses and use them to fill out the IDF. It's going to give me the paragraph of here's your technical problem. Here's a paragraph or two on the technical solution. Then I can fill in a section on here's, stuff that's similar in the space. And from there, we as a team can easily evaluate a particular invention. I also I want to highlight some other tools that you can use to make this kind of repetitive. Like ChatGPT has a functionality called GPTs, which allow you to create kind of a small custom directed ChatGPT, like version of ChatGPT. And I know some of the other providers have similar tools. And what you do is you just give it a custom instruction, and then it will execute this very task over and over for you. So like one example of one that I've used is for invention identification. Just give it an instruction saying like, you're an in-house patent counsel. You're responsible for reviewing product and technical documents to find patentable inventions. Provide a description of the product feature in these documents. I want the technical problem. I want the technical solution. And then maybe also ask it to identify things that it's already aware of or to go search the internet. You can just give it instructions, very, nice paragraph. What you do, upload the documents and boom, it spits out basically an IDF form. Or the really great use is that you can then take this and give it to either your in-house team so they can repeat things or to inventors. And then it allows them to just upload their documents. They don't need to go through this process of filling out a form, trying to understand what you're looking for. It just spits it all out for them and they can send it to you. So those are, just a few ways that I use it on the invention phase.
Okay, great.
Gideon,
Go ahead, Yuri.
I was going to say, Gideon, you mentioned, using, you actually spoke through your prompts, which I appreciate, and using terms like technical solution. And when I'm prompting, I've always found it easier to use the European Patent Office convention standards. I'd rather go with inventive step and solving a technical problem than trying to explain, non-obviousness and obviousness in a prompt. So I thought that was funny that I picked that out of your prompt there.
Yeah.
Excellent. So next up we have, and I'm looking at the time and I want to get to as many of these topics as we had queued up as possible. The next is about specification and claims drafting. And Eric, let's go to you for your thoughts on that.
Yeah. So this sort of is the follow-on step to what I just talked about, what gives rise to a well-written patent, the running narrative. So when I have sat down, and this is not using a specialized tool like Junior, this is using ChatGPT 5, let's use it as an example. This is sort of the process that I follow. I sort of address each of the discrete steps. So phase one, and Yuri, maybe you could.
Yeah,
put up
I'm loading
one,
your slides here if you'd like to
Could you
see your
put-
slides.
Maybe we'll just put up the, I think it's page 16 of the PDF, where I have an example.
Mm-hmm. Let's do that. Page 16. How about this?
Yeah,
Smart
right
mug?
there. Let's look at
Okay.
that one.
Can
Because
everyone
I think
see it okay?
sort of sums up sort of my approach. when I'm trying to draft an application and I'm using just a standard tool. And again, we can assume it's ChatGPT 5. And by the way, Gideon mentioned, useful portions of some of these AI tools. Uh, One thing that I find super useful in ChatGPT 5, and I think Gemini does this now as well, is you can go into what's called canvas mode, and you can have your document on one side and then your prompt window on another part of your screen, and you can sort of interact with the document, so you don't have to. Uh, you can sort of in real time see the changes that you're making, which is sort of similar to what Junior provides as well. But if you have more of a generic tool that you're using, Canvas in ChatGPT 5 or Gemini is really cool in terms of the drafting process. But what I put up here, and if you have a copy of the slides, you'll kind of see what leads up to this. But here is sort of the iterative process that I use when I draft an application, and I start with uh, identify the problem. Now, this assumes that I've uploaded all of my relevant documents. So I've uploaded my technical disclosure, maybe an inventor transcript if I had an inventor meeting, if I have figures or block diagrams or sketches, uh, maybe uh, the closest prior art references, maybe I've uploaded. So I have presumably uploaded all of the relevant materials already. So I'll start and I'll follow this process. My phase one, my step one is I figure out what the problem is, and I will prompt whatever engine I'm using to help me identify what the primary technical problem is. And I usually will iterate. Uh, and here's where your prompting skills really start coming into play in terms of how you articulate a prompt. Uh, I like to tell it to assume a position. So acting as a patent attorney or as a US patent attorney or as a European patent attorney, analyze the disclosure and the prior art references, for example, if I have them, and identify the primary technical problem. And I will usually I will brainstorm with the engine, right, to come up with a really nice 1 or 2 sentence statement of the problem. Or I might ask it to expand on the problem, give me a more detailed description of the problem. But I'll ultimately end up with a good statement of problem. Then I move on to my next step. Once I have that and I've anchored that, now I want to identify what my inventive concept is, and I prompt the engine to help me do that. So based on the problem that I've identified, help me identify the core inventive concept that solves that problem, right? And I will iterate here so that I get to the right level of inventive concept, not so broad that it reads on the prior art and not so narrow that it would be easy to design around, but what is the inventive concept? And then once I have that, once I've iterated to that, I move on to I anchor that and I move on to my next step of the process and I generate a claim. And I will prompt the engine to use whatever inventive concept I've identified in the previous step, whatever I've anchored, to draft me an independent claim based on that inventive concept. And here's where AI is super cool because I can use that inventive concept to come up with an apparatus claim or a method claim or a CRM claim or whatever it is that I want. And then I can prompt it to give me alternative terms or tell me how I might be able to broaden this and explain to me why that's different from the three prior art references that I've uploaded. But I can iterate to a fantastic independent claim or two independent claims or a combination of independent claims. And then when I anchor that in my process, I will move on to the drafting of embodiments and uh, I will do an embodiment at a time. Again, I don't tell the LLM to do too much because I don't want it to hallucinate or start assuming facts not in evidence. I want it to stick to what I did and anchored in the previous step. And I iterate through a detailed description, one embodiment at a time. And so I'm building my document in an iterative process, but I stick to this structure so that I maintain these guardrails and I don't let the AI uh, get off track. So that is sort of my process. And what this allows you to do, the cool thing about this, and I think what's important about use of AI is discipline with respect to the quality loop of the process. So you prompt for a specific task, you ask the AI engine to draft it. You, the human, now verify and edit and make sure that hallucinations are eliminated, and you lock it, and then you move on to the next step. And it really works well. And I'm still learning how to do it, but that is sort of the process that I've adopted, and uh, it has sort of changed the way that I approach drafting of patent applications. And you know, as Gideon alluded to, man, it speeds up the process, and it leads to a more higher quality product because you have this foil that lets you sort of ask questions, challenge a claim in real time, right? Vis-a-vis the prior art that you've already uploaded. So it's a really cool and satisfying process, at least for me.
Eric, I think you've just been the world's first at revealing a four-step prompting process for writing a patent specification. I'd like to congratulate you here live on IP Watchdog.
Yeah, excellent. Thank you very
If I
much.
may, Gene, just
Here you
to
go.
add briefly on the four-step process, which I think is great. I tend to add a little bit of do a little of this work on your own as a step to verify, you know, either that independent claim or, you know, after it drafts a broad independent claim, if you as the attorney or the, you know, the person with independent thought develop your own claim in conjunction, you can use that also as an anchor, which will help with all the subsequent steps in the drafting of this material. So I think that that's also a key element that you want to try to include as much of your own intelligence as you're working with the AI to build these applications. Thanks, Gene.
Sure, no problem. I was just going to pivot to you because probably the last segment we're going to have time to get to here is your segment on review of the spec and claims using AI.
Well, I just led into myself then. Thank
Yes.
you. Like I was saying, and Eric had already mentioned, the anchoring, you know, the concepts that you think are important and that you identify and you're using your own intelligence to build in become really important to help you verify the work that's being produced. That independent claim's a great place to start. Here are the key elements, you know, and you can even follow up with prompts into a generic model, or Junior actually handles a lot of this for you, which is why it's so impressive. You know, enablement, written description, emitted matter, a great tool to have available to you. You know, what did I miss from the disclosures that I gave you? Are there any elements I didn't describe? These are all great prompts that you can put to the model and have it highlight, and even better, extract from the disclosures that I gave you the things that, you know, may not line up to the patent application that you've drafted. And now you can actually just do this quick little review. Hey, you know what? I know that concept's in there. We're good. Oh man, we missed this detail. Inventors even said that this one's important. Let me revisit what my drafting, you know, that stepwise drafting approach, and it will actually reintroduce that material for you. Again, I think that independent claim becomes a really key element for anchoring the drafting, but also then reviewing your work. And this is one of those ways that even if material the AI produces isn't quite on point or is hallucinating, it gives you an opportunity to pull it back, fix it up, and have the confidence that final output is yours and is good and is quality. One of the things that I like to emphasize, you know, yeah, the AI produces it, but you own it. You're responsible for any of those outputs. You submit it to court, you submit it to the USPTO, you could even be sanctioned for this material if it's wrong or bad or inappropriate. And we see it every day in the news. Hallucinated case citations, right? I think at some point we'll even see the disciplinary board at the USPTO be like, you filed junk with us that isn't, I think that's a potential. So we have to be very careful. And I think that purpose-built tools are great. I think that having your general tools with persona or like conversational controls also will help you in those same pieces. And ultimately, I think someone said in the chat, these AI tools are here to stay, right? So we better learn how to use them and use them effectively. And I agree wholeheartedly. This is just going to keep growing. And we're going to see more features that will actually help you with these guardrails in particulars.
Okay, excellent. Yuri, do you have any thoughts about anything that Matt, Eric, or Gideon have said in their presentation?
Like I said, this panel of the hundreds of people I've spoken to about prompting, this panel are the ones who've spoken quite competently, and there's more people. We couldn't fit them all in here. So I just want to thank you and echo your remarks, folks. And while prompting is going to be a learned skill, Gene, we've worked to help people step into prompting. And in particularly, we found that the best way to help them step into prompting is to put their own patent drafting in front of them and ask, the foundational models to reverse engineer a sequence of prompts for every aspect of that writing so that the user can see that here is how I could have prompted to get this output. So that feedback is critical in as a process. And that's something that we have in our second video if we have time to share today.
Yeah, actually, go ahead and let's cue that up and share that right now. And
So what we did was, yeah, I guess Renee is going to share the video. Let's make sure it has sound.
Junior can help you build out prompts and prompt sequences to save to your personal prompt library or your company-wide prompt library. Let's begin by selecting a sample specification file, in which case I've selected a patent that I've written before. This is a published patent, and I'm uploading it into the sequencer. I determine which section of the patent I'd like to generate prompts for by selecting the section here. I choose which model and how many number of prompts I'd like to generate. I can optionally insert a specific instruction. Here I'm asking Junior to specifically focus on the sequence each method and system diagram is described. I hit Generate, and here Junior has generated 5 prompts that I can save now to my company library based on the sample specification I uploaded, a patent that I've drafted before. I could edit and modify any portion of this, but most importantly, I can choose which underlying fine-tuned model I want Junior to use. Optionally, I can choose that for this section, I'd like to use the model trained to write about operating environments. Whereas for this section, I'd like to choose the model trained for apparatus descriptions. In this way, whenever a user in my company loads this prompt or prompt sequence, they have the right fine-tuned models already chosen and optimized. Let's save to my prompt library. Systems and Methods Sequence Library created successfully. Now, I'm going to load Microsoft Word. The sequence is populated in my Junior. I could also find it here under System and Method Sequence. Everyone in my company can, if I saved it as a company-wide prompt sequence. Here we have, with all the selected parameters. I point my cursor where I'd like to begin drafting, and I hit Draft.
That ends the video. I don't know if it's frozen, but that's the end anyway. And so what that shows is to practice prompting. You want to see how the AI would have prompted itself to generate the work product that you've written. And through that, you could get a lot of insight into how you could structure prompts to reproduce your work product.
Yeah, I mean, I really like that because, it's so much easier, I find, to edit rather than create in the first instance, which is why I think AI is so useful to use for drafting, because it gets you down the road. Now, you may need to adjust it, not may, you will need to adjust it, you'll need to fine tune it, you'll need to make sure it's right and technically accurate and all those sorts of things. But it gets you further along, way further along, if you know what you're doing than using a patent agent or a new associate who's, just, a year out of law school or something like that. But then the trick is getting better at prompting. And if you could look at the prompt that the AI thought would give it the output that you previously created, and then modify that prompt as is necessary in any given circumstance. Well, now you're talking the AI's language, right? And that's, rather than ships passing in the night, you're telling the AI what it needs to hear in a way that it can accept what it is you're directing it to do. And I think that is really very special sauce here. And I see we're right at the top of the hour, and I know we are probably going to start to lose people because of the lunch hour on the East Coast is over, and we told you to be prepared for a 1 hour segment. But I would really like to give all of the panelists the opportunity to give your final thoughts and your takeaway message. And Yuri, will let you go last, and Eric will let you go first this time in this round.
Okay, yeah. So I guess a couple of thoughts. The lessons that I've learned in my law firm. So treat AI skills as learnable, not innate. I mean, people don't have this innate ability to use AI. I've seen all the comments come across, and they primarily relate on, humans cannot be replaced, and that is true. That's why you build the human element into the workflow. Verify, proofread. You're doing all of those things, and but I think again, speaking with respect to my experience with your people, focus on upskilling, not just deploying tools. Don't just throw tools at your people, upskill them. I mean, do what you need to do to make sure folks are trained on it. So I think those are the 3 points I had.
Okay, excellent. Great. Thanks a lot, Eric. Gideon, you're next.
Yeah, I would totally want to echo the people are not replaceable. I mean, that's not what this is about. It's about like amplifying your skills. These tools allow you to do more, go deeper with the time that you have, and they just make you more efficient. And with, specifically about prompts, kind of one of the ways that I think about it is like you want to provide a lot more detail than what you think in order to guide it. Kind of think about like you're explaining something to someone for the first time. You want them to carry out a task. That's kind of the level of detail that you're going to want to try to start with when you're experimenting with these prompts.
Great. Thanks a lot, Gideon. Matthew.
I'd like to echo everything that's been said so far. I mean, this is a tool that's going to help your practice. Use it as a tool, not as a magic button. You're going to get into a lot of trouble if you do. Be aware of the risks of using it, confidentiality of your disclosures, not allowing models to cross-pollinate across clients. These are all important things that we didn't really focus on today, but I just, ethically, I feel like I have to, pound the table on those. But in truth, these tools are great. They give you ability to focus your efforts, really reduce your review time, but think of it really as an opportunity to train this tool like you would train somebody who's working with you. I found that that's a great way to approach these AI tools because it's learning and you're learning to use it all at the same time. We've had to adapt some of our training procedures, to teach people to use this. And I think there's even, national law firms now that are identifying it as a huge factor. Just to learn AI will assign billable hours from your year just to let you learn it. And that's how important it is to the industry and how important it's going to be going forward. So continue to use it, continue to experiment with it. It will evolve, so be prepared for it to change as we go forward. And I'm looking forward to the next iteration.
Mhm. Great. Excellent. Thank you, Matthew. And Yuri, the final word goes to you.
Thank you. Large language models, generative AI, learn to prompt them, because where is our technical advantage going to be, our competitive advantage going to be as patent attorneys in our firm? You know, it's been our brand, our reputation that brings in the business, and it will remain that. But now our prompt libraries, so to speak, our know-how in using AI, as Gene, you started by saying, you'll get a good output if you know how to use it. Well, that is what we've committed to building for the patent bar. And your prompt libraries are yours. Your writing style is yours. Your nuances is yours, and protect it. You know, we'll see where our technical advantage goes in this transactional act of writing. The consultants, the litigators, they have a different path. For our path, where we do mostly writing, we have to harness AI. We have to swim ahead of the tsunami, as I often say. So thank you, Gene, for hosting such a wonderful panel today discussing these topics.
Excellent. Well, thank you all. I really appreciate you, and I appreciate you tolerating some of the technical difficulties that I had today on my end. I appreciate you all being here. We look forward to hopefully seeing you again in the future. We'll get everybody the CLE attendance document, and that's all we have for now. So appreciate you being here. We'll see you soon. Happy Thanksgiving, everybody in the U.S., and talk to you soon.
Thanks.